U.S. Department of Justice has until August 22nd to amend their complaint against the state of Illinois, Cook County, and the city of Chicago, saying that it's violating the law by not cooperating with federal immigration officials. I'm Greg Bishop. This is Illinois in Focus Daily. I'm the editor of The Center Square, and you can go to thecentersquare.com to get stories impacting you in the state. And one story we've been tracking, and we've got a development Friday late. You had the district court, a federal judge, essentially dismiss the Department of Justice's claim that the state of Illinois' migrant sanctuary policies are violating federal law. So the genesis of this is back in February when new U.S. Attorney General Pam Bondi was selected by President Donald Trump in his second non-consecutive term. One of her first actions was to sue the state of Illinois, the city of Chicago, and the county of Cook over the migrant sanctuary policies. So some highlights from the past arguments were essentially that the DOJ said the state of Illinois and Cook County and Chicago are impeding federal immigration officials, and they specifically sued J.B. Pritzker, Cook County Board President Tony Preckwinkle, I believe Tom Dart, the sheriff as well of Cook County, and Mayor Brandon Johnson. So they actually sued the individuals at the heads of these governments. And they said, again, the DOJ alleging in these court documents that the state's migrant sanctuary policies impede federal immigration officials from doing their job. And you've got the state, Cook County, and the sheriffs, and even the city of Chicago pushing back, saying that they're not the right people to sue. And they also don't have a responsibility to do this under the U.S. Constitution. And the 10th Amendment, they say, prohibits the federal government from commandeering state resources to conduct federal activities, and they can't be forced to enforce federal law. So that's the position of the state. It's not that they are not willing to cooperate. They say that the federal government cannot force the state to cooperate. So some summary points here. So the U.S. argued that sanctuary policies like Illinois' Way Forward Act, the Cook County Ordinance, and the city's Welcoming Ordinance interfere with federal immigration officials. The U.S. claims these policies cause difficult and dangerous efforts to rearrest non-citizens, endangering federal officers and others in the public, and it violates federal law. So they had several counts. One was preemption under the Supremacy Clause. Number 2 count was discrimination against the federal government under the Intergovernmental Immunity Doctrine. And the 3rd count was unconstitutional regulation of the federal government. So again, the federal government said that they felt that the states and the city and the county ordinances were essentially impeding the federal government from being able to do their job. Now, the defendants, their motion to dismiss, they said that they didn't have standing. Cook County specifically argued that the U.S. lacked standing, claiming no concrete future injury was alleged. But the court ultimately found that the U.S. does have standing to sue Illinois, Cook County, and Chicago, as the sanctuary policies pose a real and imminent threat to federal immigration enforcement, evidenced by repeated noncompliance with detainer requests and restricted information sharing over the years. Because you have Illinois, the law essentially says that local law enforcement can't not only cooperate with federal immigration officials, they can't even ask a detainee their immigration status or report an immigration status to federal officials. So the court saying that they do have some standing here, but ultimately they went ahead and they went to dismiss this because they said that the U.S. lacks standing to sue the individual defendants, Pritzker, Dart, Johnson, due to insufficient allegations tying them directly to policy enforcement. So the Cook County Board of Commissioners, that was dismissed as non-suable under Illinois law. So they've got count 1. The court ruled the sanctuary policies are not preempted by the INA, which is the Immigration and what is that? The Immigration and Nationality Act. All right. So they said the court ruled the sanctuary policies are not preempted by the INA. The INA encourages but does not mandate state cooperation. And the 10th Amendment's anti-commandeering doctrine, court said, and this is district court, protects states' rights to refuse participation in federal programs. The policies do not obstruct federal law, but reflect a permissible choice not to assist. So again, it's not that they're going out and purposefully obstructing. They're just wishing not to participate in that. So they went through the counts. Ultimately, though, what happened here is the court dismissed the DOJ's case, but said they have until August 22nd to amend their complaint, and then the case can move forward. Because the first motion here for action against the state, county, and city, it's been dismissed without prejudice, meaning they can bring it back. When a court dismisses something without prejudice, the litigants can bring it back and they can try to, change their approach and have the court re-review it. But if they dismiss something with prejudice, then the litigants can't file another lawsuit. So we have until August 22nd for the DOJ to file an amended complaint. If they don't do that by August 22nd, then the judge in this case said that the case would be dismissed with prejudice and the DOJ couldn't bring it back. So that's the latest in the case that the DOJ has brought up against the state of Illinois, Cook County, and the city of Chicago with a late Friday ruling from the district court saying that the case is dismissed and the DOJ has until the 22nd to file an amended complaint. We'll be watching, see what happens there. Obviously, I imagine we're going to hear some reaction throughout the day today to this story from maybe Governor J.B. Pritzker. He's got an event today, not related to this, but he could be asked about this particular issue. Mayor Brandon Johnson Shirley's got some comments already queued up. So we'll watch the fallout of this and report it out at thecentersquare.com. Get the podcast where you get podcasts. This is Illinois in Focus Daily.